Good morning, everyone. Welcome to our webinar this morning, where we'll be discussing the new Labour Court rules and Labour Appeal Court rules that were published in May in 2024. We are aware that these rules will come into effect on 17th of July 2024, which is almost about a month away. My name is Yvonne Mkefa, and I'm a director in the Employment Law Department here at Cliff Decker Hofmeyr. With me, I've got three esteemed panelists who will take us through the various changes, but most importantly, how these rules impact how we conduct litigation in the Labour Court and the Labour Appeal Court. I hear from a reliable source that these new overhauled rules have been 23 years in the making, but I've got an advocate, it's King, who will tell me whether I'm correct or not. And judging from what we have seen with these rules, or should I say, looking at the from and to picture, I believe that these amendments bring about greater clarity and a streamlined court practice in the Labour Court and the Labour Appeal Court as higher courts in South Africa. By way of example, we know that there were instances where we needed to resort to the High Court's uniform rules, where the Labour Court rules were silent on certain aspects. We also had various directives, and we also had a practice manual that were issued as mechanisms to improve court practice, which would then allow for expedient or expeditious dispute resolution. So let me introduce you to our panelist. We've got Advocate Riaz Etzkin, who is a member of a Johannesburg bar and a part of the Group 1 Advocates. We also have Fiona Lepan, who is a director in the Employment Law Department here at Cliff Decker Hofmeyr Incorporated. We also have Lee Masuku, a senior associate in the Employment Law Department here at Cliff Decker. Let us start with Riaz. So we now have these new Labour Court rules and Labour Appeal Court rules that will come into effect in July. I've been hearing phrases such as winds of change, at last, long overdue, which, by the way, to me sounds all like song titles. But what I want to hear from you, are these new rules good? Are these new rules needs met for litigants, practitioners, the registrar's office, the judges, and all other stakeholders? And if yes, why do you say so? Riaz?
Thank you, Yvonne. I think the starting point in unpacking your question is to understand what one is dealing with labour litigation and how it's different from other litigation. And then once one unpacks that, one can look at whether the current rules meet the objectives that should apply to labour litigation and whether there are any gaps, problems, or other inefficiencies in those rules. And I think, Yvonne, a useful quote from a Constitutional Court judgment in 2022, Boy versus Amatole District Municipality, really sheds light on the differences between labour litigation and other litigation. And that's probably the starting point in answering your question. What the Constitutional Court said there is labour litigation, as envisaged in the LRA, is distinct from any other civil litigation. The Court said this is made abundantly clear in the preamble to the LRA and through the specialized systems and institutions created by the Act. It has also been affirmed by this court recently. It follows that labour disputes must not be perceived as ordinary civil disputes by the courts that adjudicate them. Our law is clear, says the Constitutional Court. Labour dispute resolution must be expedient, simple, accessible, and cost-effective. So those are the principles that uniquely apply to labour litigation. Expedient, simple, accessible, cost-effective. And the question really, Yvonne, is whether the Labour Court rules in their current form meet this objective. Do they create a system that is expedient, simple, accessible, and cost-effective? The current Labour Court rules were adopted back in 1996. That's shortly after the Labour Relations Act itself was promulgated. They went through some amendments in the succeeding years. There were amendments, for instance, in 1997, in 1998, and in 2001. And those amendments served to tweak those rules. But by and large, the architecture of the Labour Court rules remained the same. And they contained gaps in many areas. Yvonne, in your remarks a short while ago, you mentioned that one drew from the High Court rules in many areas where there were gaps in the Labour Court rules. It really was a case of labour lawyers and judges finding ways to fill the gaps. A good example of that, for instance, was the exception procedure, where the Labour Court rules didn't include an exception rule at all. And one would look to Rule 23 in the High Court rules to draw from that on how one would deal with an exception, which is an objection to a pleading being vague and embarrassing or not disclosing a cause of action. And this led to a stream of jurisprudence developing in the Labour courts, drawing from certain High Court rules in order to plug those gaps. But it also emerged from that jurisprudence that there is an inherent tension in doing so. Why? Because as the Constitutional Court said in the quoted extract, we're not dealing with ordinary civil litigation. We're dealing with labor litigation, which must be expedient, simple, accessible, and cost-effective. And the High Court rules aren't designed and bespoke for this kind of litigation. So it was almost in some cases trying to fit a square peg in a round hole when one would draw directly from certain High Court rules. And this tension is evident in some of the Labour Court's judgments dealing with the application of the High Court rules, where the courts have made clear that although one may draw from the High Court rules, one mustn't go further than one needs to in drawing from them and adopt an overly technical approach in labour litigation, which then causes labour matters to be plagued by technicality, point taking, and so forth. And that really flies in the face of a system which is, to draw again from the Constitutional Court's words in Boy, expedient, simple, accessible, and cost-effective. The new Labour Court rules, which come into effect in just over a month, are revolutionary. They're not simply evolutionary, like the amendments tweaking the previous rules were. They are a complete revision of the rules from top to bottom. So one might say the rules of the game have literally been rewritten from start to finish in the new Labour Court rules. And the nearly 30 years of the current rules being in operation have allowed for the Rules Board to identify many areas in which they could streamline the rules, ultimately with the objective of meeting those standards that the Constitutional Court in Boy described: expediency, simplicity, accessibility, cost-effectiveness. And really what will emerge from this seminar, from what I have to say, and I know what the other speakers have to say, is that there are a number of efficiencies which are now incorporated or will now be incorporated into our system as a result of those rules. But of course, the question then is, well, there is ongoing litigation, and how do the new rules impact on litigation which has already commenced prior to the introduction of the new rules? In other words, do the new rules have retrospective effect? Will they apply to things that have happened before? If not, do the old rules apply indefinitely to litigation that commences before the new rules come into effect? Or is it a case of the new rules kicking in and applying to current litigation with effect from the 17th of July? Those seem to be the three possible permutations. Now, the new rules don't themselves contain specific transitional provisions or arrangements. So they don't particularly and specifically deal with this issue. And to use a simple example, what if a case is launched on the 16th of July, 2024, the day before the new rules come into operation? Will the old rules then apply to that case until judgment is delivered because it had its genesis, it was born in the old dispensation? Or do the old rules apply until the new rules kick in on the 17th, which would really be for one day on the example that I've provided? There is some guidance from our case law, not directly in point, but I think useful to try and unpack the position. In 2019, the Labour Appeal Court delivered a judgment in Max Steel Trading Wadeville versus Van der Merwe and others. The matter involved the practice manual of the Labour Court, which came into operation in 2013. The practice manual, as we know, deals with some practical issues in the application of the Labour Court rules and in the practice in the Labour Courts. And it even includes some provisions to plug the gaps that I've explained have come to light during the nearly 30 years of the old Labour Court rules being applicable. So the practice manual comes into operation in April 2013, and the issue in that matter was whether it applied to litigation that was launched before the practice manual existed. In other words, a matter is launched before April 2013. The matter is as yet unfinalized in April 2013, and there are still litigation processes which must happen post-April 13. And the issue is, well, does the practice manual apply to what happens post-April 2013 in that case? The Labour Appeal Court found that the practice manual did apply to that litigation as from the date on which the practice manual came into operation. In other words, there could not have been a breach of the practice manual before it existed because it doesn't have retrospective effect. But the requirements of the practice manual must be adhered to as from April 2013 in that piece of litigation, because it is now regulated by the practice manual. And it appears likely that similar reasoning would apply to the new Labour Court and Labour Appeal Court rules. In other words, as from the 17th of July, they will need to be complied with, and prior to that date, the current rules will apply. There was also a High Court judgment delivered on Monday this week, as it happens, which I think also provides a useful indication that that is the position. The High Court judgment involved a matter between the economic freedom fighters and the Speaker. And in that matter, one of the issues that arose was Rule 67A of the High Court rules, which regulates costs, is a new rule which only came about on the 12th of April 2024. The litigation had been launched long before that, but was finalized after that. The judgment was delivered on Monday this week. That new rule deals with costs differently from the old costs dispensation. And in the judgment, the court had to decide how to deal with costs now that there's a new rule which has come into effect and which rule applies for different time periods. And in effect, the High Court applied the old costs rule up until the 12th of April 2024 and made a costs order that as from the 12th of April 2024, any costs that were incurred would be dealt with on the tariffs in accordance with the new rules. And this is really in keeping with what I've said about the Max Steel Trading judgment, that the old dispensation applies up until the cutoff point when the new rules come into effect, and then they kick in and apply to ongoing litigation. So that appears to be the position. The next topic that I'd like to touch on, if I may, Yvonne, is review applications and how the new rules deal with reviews, because that is one of the more significant changes to the dispensation compared to how things are done at present. Now, one of the largest contributors to the Labour Court's caseload we know are review applications. That is, applications to review CCMA or bargaining council arbitration awards. And this is understandable if one looks at the huge caseload of the CCMA. I mean, the CCMA really is at the coalface of dealing with labor disputes, dismissal disputes, unfair labor practices, and so forth. And it literally deals with hundreds of thousands of cases every year. Now, not all of them make their way to the Labour Court on review, but there is a significant number of judgments which are taken, of awards which are taken on review to the Labour Court. And that then creates a huge caseload which the Labour Court must deal with. And there have been some significant changes which the rules will bring about to this area. The current approach in review applications is to file detailed founding affidavits setting out the grounds of review, and in many instances, the evidence that was led, and in some instances also the argument that is to be advanced in relation to that evidence. This is then amplified in a supplementary affidavit once the arbitration record is made available by the CCMA, and very often the supplementary affidavit contains long tracts of quotations from the transcript, which has now been produced by the CCMA or the Bargaining Council, and then a lot of argumentative matter about how one should understand and apply those transcripts and why the arbitrator reached an unreasonable finding. So the question really is the current model in review applications where all of this happens in the exchange of affidavits to draw from the Boy judgment again, expedient, simple, accessible, and cost-effective. It costs a lot of money to draft reams and reams of paper. It is very inefficient, some might say, to have to debate all of those things extensively by way of affidavits. And a very significant change that the new rules bring about is a requirement that a founding affidavit in a review application must contain, it says, no more than a concise statement of the grounds of review. The applicant must, according to the new rules, state whether the whole or part of the award or ruling is sought to be reviewed. Secondly, it must record in point form each error or misdirection alleged to have been committed with reference to the award or the conduct of the decision maker. And thirdly, it must state concisely, and I underline the word concisely because that's in the rules, why the errors or misdirections caused the result of the award or ruling to be unreasonable or irrational in relation to the evidence led. There's also a new provision that in exceptional circumstances, factual averments may be concisely, again, the word appears concisely, incorporated, and any abuse of this exception will be penalized by a costs order, say the new Labour Court rules. So under the new dispensation, a review application will need to be approached in much the same manner as an application for leave to appeal would currently be approached, with far less paper and argumentative matter, and really setting out in point form, in bullet point form, literally, what the issues are without argumentative matter or even factual averments or references in detail to the evidence. So there'll be far less paper, far less argumentative matter, if any, and far shorter affidavits. So in practical terms, whereas one might have a founding affidavit in a review application today, which is 20 plus pages long, what we're looking at with this change is a founding affidavit of perhaps 3 or 4 pages, which really just gets to the heart of the issues in the matter and says no more than it needs to say. And this approach makes sense because we know that the review test, as it's developed, particularly when one is dealing with reasonableness review, looks at the commissioner's decision and tests it against the evidence which was before the commissioner, and an overall assessment of the evidence is then undertaken. And we know that a review court ordinarily will have that evidence in the record in front of it. So it's really redundant for a party to narrate in an affidavit what the evidence was or paraphrase selectively from that evidence when the review court will have to look at the evidence in any event in due course and determine whether on the actual evidence and not what the parties say the evidence was, the reasonableness threshold is met in relation to the outcome. So there's really no point in having extensive pages with parties paraphrasing the evidence, which the court will itself have to look at. And the new rule really does away with that. There are also some time periods which have been incorporated into the new rules to ensure that review applications are prosecuted speedily. And here one goes back again to the Boy principles. And the first one is that dispute resolution in the labor space must be expedient. And it seems that these amendments are designed to facilitate that by ensuring that matters don't drag on for years and years, and that parties, at least in relation to their role in speeding things up, act with the necessary expedition and speed to make sure that the litigation progresses. One of the time periods in the new rules pertains to the filing of records. I've mentioned records in the context of the review test. There is a 60-day time period within which to file the record as from the date when the registrar advises that the record has been received. And this isn't a new provision in the sense that the current practice manual deals with it, but it's new to the rules. In the sense that there's now a labor court rule specifically dealing with it. I'd mentioned earlier, Yvonne, that the practice manual attempted to plug some gap in the rules in order to facilitate the orderly running of matters in the labor court. And this is one of the areas in which it did that. And so now we have it directly dealt with in the rules. Another aspect drawn from the practice manual into the new rules is that a review application is deemed to be withdrawn if the review record is not filed within the prescribed 60-day period unless consent is requested and received from the other party or an application is made to the judge president for an extension. And this is obviously quite a drastic provision in its effect aimed at ensuring expediency, because deemed withdrawn really deems the matter to have been withdrawn by the applicant in the review. So if the applicant hasn't taken this step within the 60-day time period, the litigation is effectively dead.
What does that mean then for the applicant, Riaz?
Yes, Yvonne, good question. So I mean, at a practical level, and this is a matter which the Labour Appeal Court has given some attention to under the practice manual provisions on deemed withdrawal. There's a judgment, e-Tradex, in which it considered what the impact of this is. In other words, if the time period lapses and a matter is archived or deemed withdrawn, which is the language of the practice manual, the LAC had to look at what that means for a litigant. Does it mean the registrar must physically take the file to archives in order for it to be archived, or does it have automatic immediate effects on the ongoing litigation? And in the e-Tradex judgment, Yvonne, the LAC said it has automatic consequences for the status of the matter. In other words, the moment the matter is archived or deemed withdrawn, there's no physical step that an administrator needs to take. The matter is effectively, as I've described it, dead, unless there's an application to reinstate or revive the matter. And the new rules do recognize that there is scope for a reinstatement application or a revival application. What that involves effectively is a party showing good cause for non-compliance with the relevant time periods. And the way the courts have dealt with this, Yvonne, is to draw from the principles on condonation applications, where you'd explain the reasons for lateness, where you take into account the extent of the delay, and you'd look at matters like prospects of success, prejudice, and other public interest considerations. So there is scope for a defaulting party to have a matter reinstated or revived by bringing an application to have that happen. But of course, we know that from the condonation space, the courts repeatedly say condonation is not there for the asking. It's not easily and automatically granted. It's an indulgence. So it's not a simple out for a party to say, well, we'll simply apply for reinstatement. We can drag our feet in this matter. The provisions are really designed to speed things up, ensure expedition, and to create consequences where expedition isn't applied by an applicant in a review application, in order to encourage parties and effectively force parties to deal with matters effectively and expeditiously. I know that some of the other speakers will be touching on other inefficiencies which are addressed by the rules, Yvonne. Those are really the main changes to the review rules. There are certain others relating to time periods in reviews and so forth, which are in the new Rule 37. But for present purposes, Yvonne, I think we can leave it there.
Thank you so much, Riaz. I've got just two comments. The one is punitive cost order when it comes to review, because as you said, the bulk of court practice in the Labour Court is reviews. So when these rules start talking about cost orders, when we know what the rules are in relation to, or the court's approach in relation to cost orders, so there actually has to be a level of diligence, even in relation to deemed withdrawals, because as you say, condonations, and I would assume these deemed withdrawals are not just for the taking. Someone needs to plead a compelling case, and we just don't want the courts to start punishing litigants for taking a very relaxed and non-diligent approach to these. And the second one is about transitional arrangements. I think you made mention of the McStill judgment, and I think if I'm not mistaken, that there was also a Samuels versus Old Mutual case that also dealt with the same thing. And I think it's also worth us at some point considering it. But I think the principles are clear, because these rules are meant to make court practice quite efficient. I'm going to move on to Lee. Lee, we've heard Riaz saying that the rules have been revolutionary as opposed to evolutionary. He says that the rules of the game have been rewritten. Can you just tell us what some of these changes look like? Is it true that these rules have changed? These rules have changed the game on how we do court practice, and maybe you can also refer us to some specifics.
Thank you, Yvonne. Yes, there are two instances which I'm going to refer to in the manner in which the game has so-called changed in the Labour Court. The first being that previously it was recognised that the 4 seats of the Labour Court comprised the national seat. And what that meant is that parties could proceed to any one of the 4 seats of the Labour Court to initiate proceedings. However, what the new rule set out is that a dispute must be, or a proceedings must commence where the dispute arose. For example, if I was dismissed in Johannesburg, I then have to proceed in the Johannesburg Labour Court, despite where the employer might be based elsewhere in one of the other 3 seats of the Labour Court. The rules to provide that the judge president can provide for an exception to this general rule, but principally parties must now institute proceedings in the the court nearest to where the dispute arose. A second example of how the rules have changed the game is that the new rules do away with service by fax or registered post, and they introduce the service by email, which was only previously dealt with in a practice directive, which was issued by the Labour Court about a year or two ago. Now it is recognized in the Labour Court rules that service may be conducted by way of email. As has always been the case, parties may prove service by way of a service affidavit. But insofar as emails are concerned, it's important to note that there are specific requirements that must be set out in a service affidavit in relation to service by email. First of all, a deponent to a service affidavit must provide proof of the correct email address. They must also confirm that the whole email was sent, and they must also confirm, and this is important, that they spoke to a named person, and that named person confirmed the whole email was received. Elsewhere in the rules, it also does provide that certain provisions of the Electronic Communications and Transactions Act apply to service by email. Practically what this means is that it appears that the rule suggests that an acknowledgement of receipt it will be accepted if it's a read receipt, for example, or confirmation of receipt by email. However, for whatever reason in the rules, this is set out separately to the requirements for service affidavit dealing with service by email. As a result, it may still be best practice to follow the specifically required, the specific requirements of a service affidavit, which means that you must still telephone a person confirming that the whole of the email was received.
Yvonne, you're on mute.
Apologies about that. Thanks, Lee. We also heard Advocate Itzing mention that the new Labour Code rules in many ways mirror the High Court rules. What are some of the ways that this is the case with the new rules?
One of the interesting developments, Yvonne, is the way in which the term day has now been defined in the Labour Court rules. To exclude the period between the 16th of December and the 15th of January. This is what the High Court refers to as days non, or days on which the court doesn't sit or carry on business. What this practically means for parties is that if service of a document or process is required during the days non, the last day of service will then move over to the 16th of January. So one can accept that, the ordinary South African holiday period now is in effect in the Labour Court as well as a general principle. Another example of this, Yvonne, is the issue of a notice of bar, which is also one leans on has been incorporated from High Court principles. What this means is that where a defaulting party has not filed a specific pleading, a party can issue a notice requiring the defaulting party to deliver the pleading within 5 days or another period agreed to between the parties. If the defaulting party does then not do so, the party issuing the notice of bar, they will then be barred from delivering the pleading going forward. Once a party is then barred from delivering the pleading, that bar can only be removed on application to the Labour Court, and good cause must be shown for why that bar must be removed.
Thanks, Lee. I mean that's quite clear. Maybe the last question from my end. We heard Riaz talking about some changes to timelines and time periods. Are there any other ways the new Labour Code rules have impacted on the timelines provided for delivery of process?
Yes, Yvonne, insofar as action proceedings are concerned, that is referrals. A referring party must now Once 15 days after a referring party, or apologies, 10 days after the referring party has filed a statement of case, a party must now deliver a notice of intention to defend if they intend to defend the action. If no notice of intention to defend has been delivered, then a party, the referring party may set the matter down for default judgment. Once a notice of intention to defend has been delivered, 15 days thereafter, an opposing party can now file their statement of response. This is a slight extension from the ordinary 10-day period in the current Labour Court rules. And although not specifically related to time periods, it's important to note what the new rules state about what must be excluded from a statement of response. And in that regard, it states that poison lemonade must not be mentioned in a statement of response. It must now be dealt with as a preliminary matter, separate in either an exception, a special plea, or other appropriate pleading in the Labour Court, provided for in the Labour Court rules. The new rules also, they now recognize that a party may file a replication, which is essentially a reply to the to the statement of response, which was not previously recognized, and that can be done within 10 days of receipt of the statement of response. There is also further pleadings which are allowed by the Labour Court rules, similarly to what is provided in the High Court rules for counterclaims, and these are called pleadings in replication. Insofar as motion proceedings, and I'm speaking more about general motion proceedings, the only major timeline change has been in respect of the filing of heads of argument. For example, previously, heads of argument were drafted upon a receipt of a directive from the Labour Court. Now, the Labour Court rules specifically provide that within 15 days of close of proceedings, an applicant must file their heads of argument, and a respondent must do so within 15 days of the hearing date, regardless of whether or not the applicant has filed their heads of argument.
There's a definite shift in the court practice, and I think there's also a level of self-management that is required of litigants, and probably is also lessening the burden from the registrar's office, which is actually quite critical. Thanks so much, Lee. I'm going to move to Fiona. Fiona, there are three areas that I'd like for you to, three rules specifically, that I'd like for you to take us through. The one is relating to media access to proceedings, which is Rule 73. The second one has to do with urgent applications. And the last one has to do with the applications in relation to restraint of trade. Let's start with Rule 73, which is media access to proceedings. What is the origin of this rule? These are the questions that I'd like for you to touch on. How will this access be granted and by whom? What does it mean for practitioners when advising their clients? Should their matter be conducted in the glare of the media? Because we've seen that there's actually an uptick there. And what type of matters might attract such media attention? And then we'll move on to the next two. Thanks, Fiona.
Thank you very much, Yvonne, and to all of our members of the audience. I think you'll find this particular aspect quite fascinating because one needs to understand why such a rule was introduced now in the new amendments that we are seeing coming into force and effect. Media access is not necessarily something new. It does centre upon the principle of open justice and the fundamental right to access to the courts. Members of the public need to understand and have a right to know what is transpiring in important cases and with a view to following that. It's nothing new for the purposes of the Labour Relations Act per se, because Section 160 has always said that the proceedings in the Labour Court must be held in open, if you like, open court. And that is to allow access so that persons can understand what is happening in those proceedings. But we all know that many people can't attend court. They're at work. They're busy with other activities, but important matters are being adjudicated in these fora, and they want to be able to follow that. And the leading case, which dealt with this a few years ago in 2007, went as far as the Constitutional Court in South African Broadcasting Corporation versus the National Director of Public Prosecutions. And this particular matter centered upon oral argument that was being delivered in a matter concerning an appeal by Shabir Sheikh in his corruption trial. And the matter in the Supreme Court of Appeals centered upon whether or not this live broadcast of the oral evidence should be permitted. The Supreme Court had refused that permission, feeling that it would put undue pressure on judges, on counsel that was appearing for the parties, and prejudice the right to a fair trial in what was then a pending case against former President Zuma, because, of course, the concern was that broadcasts might deter witnesses from testifying in those subsequent proceedings. But the Constitutional Court back then in 2007 adopted quite a conservative approach. It was particularly concerned about the prospect of any recording of evidence and the character of the proceedings that take place could be distorted because there could be a tampering with the visual or the audio recordings without anyone being able to detect that. But in a very powerful minority decision of our then Deputy Chief Justice Moseneke, he didn't agree with that. He believed that open justice principle required that these matters be recorded, be transcribed, be available, and more importantly, that live television recordings be permitted. And I say that because that's back in 2007. Interestingly enough, the North Gauteng Practice Manual amendments back in 2012 supported Judge Moseneke's suggestions and, more importantly, the findings he made in that powerful minority decision. And what's fascinating when you read those particular aspects of the North Gauteng Practice Manual, they're replicated in Rule 73 of our new Labour Court rules coming into force and effect. What does that mean? Certain elements of the proceedings before court do not require any application to court for permission to televise, broadcast, etc. That is court activities 15 minutes prior to the court being in session, any period of adjournment, and of course at the end of proceedings. But during the proceedings itself, should the media wish to be in attendance, that's by way of application to court on at least 24 hours notice. And of course, in granting such an application, our court will definitely have regard to the principles that I have alluded to, but it will control the number of media in attendance. There will not be any lighting permitted in court, which can be to the distraction of proceedings. Media must provide their own equipment and be responsible for it and remove it at the end of session. And of course, there are certain obvious prohibitions which will not be permitted even by way of application, and that is no recording of bench discussions is permitted, no close-up photography of private, confidential or legally privileged issues. So the media could not, for example, seek to record and televise a private discussion between counsel and client, because that would interrupt our well-known principle of legal privilege. And close-up recordings of the bench and the judicial officers and litigants and practitioners is not permitted. And there's a prohibition against this type of media coverage being used for a nefarious intent, for commercial or political advertising. That's not going to be allowed. But of course, when we look at the way Rule 73 has been drafted, we also have to take great cognizance of the fact that with technological advances, we see so much more happening in our courts. If we go to the Zondo Commission, we had live coverage of counsel in action, litigants testifying, etc., in the full glare of the media. And that tends to put quite a strain on your question, Yvonne. How does one advise a client in these circumstances? You might have a slightly reluctant witness who's terrified of being in the glare of the media. And how do you manage that? If the case is deserving of media attention, one's going to have to certainly settle a witness and ensure that the best is done to ensure they can comfortably testify. But there's no doubt that it puts a different strain on a witness, because suddenly you're on stage, so to speak. And in the well-known Commission of Inquiry involving Hansie Cronje, the late Hansie Cronje, the cricketer, our captain of our South African team, who disgraced himself back in the year 2000, it was one of the issues that the Commissioner was against when an application was made all those years ago to have media coverage of those proceedings. And in fact, that media coverage was video, camera and radio. But what the Commissioner was unhappy about is the sudden glare which places emphasis on the tone of voice of a witness, of hesitations when testifying, because you don't actually pick that up when you read a record, but when you see televised recordings, that's very much evident, and it starts to impact on potential credibility of a witness. Are they sure of their case? Are they confident? So this is going to require some precognition with regard to how you manage witnesses in this way. And then what sort of matters would one expect to see covered by the media in the Labour Court? I think in the collective bargaining space, certainly strikes, lockouts could potentially bring about an application for media attendance. I'll give an example, maybe the sympathy strike that was called by AMCU in the platinum sector some years back, which led to litigation in obviously the court on the protected nature of a sympathy strike, where really AMCU was looking to bring out the whole of the platinum sector in support of workers who were on strike at Sibanye Gold's operations in relation to mutual interest issues. I think certain harassment cases could bring about this type of request. It's got to be obviously high profile, because that's why the media would want to be there. But I do believe that the court has sufficient discretion to decide whether it's appropriate for media access to particular information and or evidence that's being led. Thank you.
Thanks, Fiona. I think the one also that comes to mind when you talk about high profile, you may also see cases that involved executives in our clients, and talking about agent applications. Maybe let's move to the next area.
Yes.
I'm mindful of the time, so I'm just going to go straight to it. So agent application in terms of Rule 38, are there any changes to the requirement of agency when launching such an application? Are there changes regarding how the applicant approaches the court in the agent application proceedings? And lastly, what are the requirements under the new rule regarding service of application on the respondent parties?
So we know that one of the aims of the new rules is to seek a consolidation of what we found in the practice manual, because it will now be repealed, and what was needed or what was existing at the time in the rules. And that consolidation finds its home in relation to Rule 38 governing urgent applications, because there's a need for cooperation with the registrar before the proceedings, or rather the initiation of those proceedings, gets to the point of service. What one requires is an approach to the registrar with your initiating documents. That would be your application, your notice of motion, etc., your founding affidavit, your annexures. You would want an audience with the court in order for the registrar to fix a date, time and place when the matter will be heard. And there's an element of case management to this, for the simple reason that it's not up to a practitioner to decide when their application is going to be heard. They're acting for the applicant, but rather there is the cooperation. There must be that cooperation with the registrar to explain the degree of urgency so that the appropriate date can be set. And what has changed is the Tuesday-Thursday scenario, which excluded, by the way, urgent applications for strikes and violence associated with strike action. Here, because the registrar is controlling that court role, it will be a decision taken by the registrar as to when your matter will be heard, but that's based on the urgency of the matter. But the importance of initiating, having those initiating documents ready, having the registrar provide you with date, time and place, you insert that into the notice of motion, you're ready to serve. And I think that's to effectively manage the court's role. And that sympathy strike that I spoke about really did bring to the fore a stretch of the court's resources at the time, because the week where companies were now contesting the protected nature of the intended sympathy strike was a week where the court was already seized of a number of restraint of trade applications. And suddenly 10 more applications was placing an undue burden on the court as to how and when they could be heard. And the judge, President, asked Judge Andre Fenicek to facilitate the case management of the matter so that all 10 applications could be heard on a specific date, and parties would come and argue their respective cases in court instead of litigants deciding when they were going to approach the bench, or the court rather, for their matters to be heard. And I think that's a very important aspect. On service, the court will want to ensure that the respondent parties have been adequately advised of this application that is being launched. And it may be by personal service, it might be by email or any other means. And we know any other means has, in fact, been quite creatively dealt with by practitioners over the years. The use of SMS, text, WhatsApp, even in one of my matters, the service of proceedings by way of Facebook, and it was permitted, but there were reasons for it. But there must be adequacy in bringing the proceedings to the attention of the respondents that are impacted by the relief sought.
Thanks, Fiona. I think that the next one in relation to restraint of trade is actually of great interest, because there was a time where it was believed that these could only be brought in the High Court, and we also saw litigants then approaching the Labour Court. So there's a Rule 39 that specifically deals with restraint of trade. What does this new rule require with regards to the exchange of affidavits? How does one have the matter enrolled when there's a likelihood need to launch the matter on an urgent basis?
Thank you very much. To Advocate Itzken's point, this is a rewriting of the practice manual and also how we've managed restraints in the past. It's a new rule, it's an important rule, and it's talking to the efficiency of dispute resolution. Now, room is made in Rule 39 for a departure perhaps from some of its requirements in very urgent circumstances, i.e. particularly with regard to when the matter will be heard. But perhaps I could start by saying that in the ordinary course, restraint of trades, that application must be brought by way of notice of motion and exchange of up to 4 sets of affidavits. So you have a founding affidavit, to be brought within a period of 7 days, the answering affidavit and a reply, and the opportunity for a fourth set is already written into the rules itself. Now that's quite important, because in previous cases you would know that you're not automatically permitted to file a fourth set of papers. And why is it a requirement now? Because the court is saying, well, if we're going to be looking at efficiency reasons, we know that new matter is often found in the replying affidavit by the applicant that the respondent needs an opportunity to deal with. Previously, one would have had to have applied and asked for the opportunity to lodge that fourth set, and that's at the discretion of the court, and that's certainly something that the High Court managed over many years. Now that we have this opportunity as a matter of right in the Labour Court, I think that you'll see more matters coming to this forum. Not to say that we haven't seen a gradual increase in restraints being managed by the Labour Court, and the reason for that is it's matter emanating from the contract of employment, and the court's jurisdiction is founded in section 77 sub 3 of the Basic Conditions of Employment Act. So how does one tackle setting the matter down? You filed your papers, or you're ready to launch, I should say. You're going to be allocated a provisional date, and that's something that one has to confer with the registrar about, and that must take into account the mandatory time periods that I've spoken to, which is of course the time periods for putting in the answer, the reply, and the fourth set, as well as heads of argument. And that provisional date is set not less than 7 calendar days after that application is launched, and it will be heard in that time frame if the matter, of course, goes on an unopposed basis. But invariably, restraints are hotly contested. That won't easily happen. And of course, what can happen is that upon the receipt of the fourth affidavit, you can't live with a provisional date. That's come and gone because the matter's opposed. You need to be able to enroll the matter, and there's steps taken in terms of indexing the matter, ensuring that there's been a running pagination of those affidavits as they're filed, and then one is required to approach the registrar for a date for that final enrolment of the matter, by which stage, of course, the heads of argument have to have been filed within 5 days of indexing of the application, and that's obviously on notice to all parties that are affected by this matter. But what I like about this particular rule is that if your matter is more urgent, that you're able to advance that before the registrar, and that might change this particular set of steps that need otherwise be taken. And it might even result in some form of interim relief pending the matter being dealt with in terms of the time frame set out in Rule 39.
Thank you so much, Fiona. And I think that the three aspects that you've also touched on, because they are quite, I think, new in the timelines, and we know that we see these more often, and that and some of them have been addressed in some of the practice manual. I think that just brings everything, I think, into focus, and we are clear on what needs to happen. We actually are probably 30 seconds away from the end time of our webinar. And I see that the panelists have been responding to some of the questions in the chat box. I'm highly indebted to everyone who has been responding, and if there are any that are coming through still, we will endeavor to respond to those and then send them to the attendees. And we've also invited you to visit our website for articles that pertain to these rules, because we also deal with the aspects that are that are actually going to be quite critical as you transition. There was one critical question about whether or not these rules replace the practice manual in the directives, and the answer is yes, because the attempt of the rules, the rules board was to make sure that they consolidate everything that has been evolving over the time since 30 years ago, that is actually contained in one set of code rules. So the answer is definitely the yes. For any other questions and support, we also invite you to speak to the attorneys. You can contact us and we'll be able to assist you in that respect. And if you need us to make any presentations to US clients, absolutely, we are more than willing to do that. Thank you so much, everyone, for attending, and I'm sorry to take a minute away from your for your next commitment. Thank you. Have a good day further.